Welcome, everyone. I'm Maria Volpe. I'm a professor at John Jay College and director of the Dispute Resolution Program. This roundtable breakfast is co-sponsored by the Association for Conflict Resolution of Greater New York and the City University of New York Dispute Resolution Center at John Jay College of Criminal Justice. We're so delighted that all of you could be here with us again. And for those of you who are here for the first time, welcome. This is our opportunity each month on the first Thursday of the month, unless it falls on New Year's Day or the 4th of July or some other holiday. We always meet on the first Thursday. This is our 281st gathering. I started these events after 9/11, and we met in person until April 2020, when the pandemic started. We pivoted to this online modality, and it seems to be working. We were thrilled to be able to host an in-person event last month. And at this point, we think that we will try to do an in-person version, perhaps in the fall and in the spring, and continue with this online modality. I know many of you keep asking us, are we going back to only in person? It is absolutely wonderful to see everyone in person, but it's also absolutely terrific to be able to have this huge gathering each month. These events would not be possible each month if it wasn't for a wonderful team I'm a part of. That includes Nikki Borofsky, Matthew Latimer, Chloe Choi, and Sherston Pugh. Each month, we are so pleased to have colleagues join us and share with us their most recent work, their thoughts, their theories, their practice, whatever is on their radar screen. And so I am going to turn this over to Nikki to introduce our wonderful speakers this month. Thank you so much, Donna and Kelly, for being here with us. And take it away, Nikki.
Thank you so much, Maria. I'm going to keep it really short today. I just wanted to reach out and say thank you to everybody who came to last month's in-person meeting. And as we move forward, we're really investigating how to bring all of the great ways to convene together into more and more interesting and innovative and useful formats. But I want to thank you for joining us today for our roundtable breakfast, where we are thrilled to welcome two leading figures who are shaping the future of family dispute resolution, Professors Kelly Browe Olson and Donna Erez-Navot. Today's topic, which is family dispute resolution, a glimpse of the past and a look to the future, examines the evolution of FDR and envisions what lies ahead. It's a really good moment for kind of reflecting, I think, especially for those of us who find ourselves in America, where history is kind of in the making as we live and breathe. Professors Browe Olson and Erez-Navot bring invaluable perspectives from both their recent book and their work on the ABA AFCC Taskforce, which is charged with updating the model standards for family and divorce mediation. Professor Kelly Browe Olson hails from the University of Arkansas Little Rock Bowen School of Law and is a distinguished family dispute resolution educator and co-editor of Family Dispute Resolution, Process and Practice. Her work really shines a light on how mediation can better address complex family dynamics, including intimate partner violence and unrepresented litigants. She's also serving on the ABA AFCC Taskforce and contributing to this pivotal revisioning of mediation standards. Professor Donna Erez-Navot is the director of the mediation clinic at University of Florida Levin College of Law. She is a pioneer as well in developing innovative mediation programs and is a co-editor of Mediation in an Evolving World. She is a reporter for the ABA AFCC Taskforce and is guiding the updates that enhance empathy, flexibility, and inclusivity in family mediation. And this talk today really goes beyond FDR. The principles that we'll be discussing today include trauma-informed approaches, accessibility, handling diverse client and participant needs, and this is really applicable across all dispute resolution and across all of our lives. As conflicts grow more complex, we are all called upon to adapt and refine our practices for more inclusivity and responsiveness. And I think it's an important, timely message at this moment. Please welcome me in giving a warm welcome to Professors Kelly Browe Olson and Donna Erez-Navot. And also, I just want to say before handing the microphone off officially, that in our previous talk, you should feel free to pop your questions into the chat. The professors will both kind of be keeping an eye on them and trying to respond in time where there's something that's relevant, and hold that question or the response to that question until later. And then also we've built in, or they've built in, about 20 minutes of response time afterwards. So anything that we don't get to or they don't get to should be able to be responded to in that time. So without further ado, I am presenting the platform to the two professors and really look forward to this conversation. Thank you so much for joining us today.
Thank you so much for having us. I'm going to start my PowerPoint soon, and we will be sharing the PowerPoint afterwards with the with everyone who's participating, so you don't need to worry about that. It is just such a pleasure to be a part of this program this morning with Donna. Especially, we've been doing a lot of work together recently, and I'm just excited to get to talk about the book and the guidelines. And also, as Nikki said, we will be leaving plenty of time for questions afterwards, but please put your question in the chat as well, and we'll try to get to them too. I'm going to start sharing, but before I do, I just wanted to introduce myself a little bit, and just had a great introduction, so I don't need to, but we did work on the book for about almost 4 years, and we've been working on the guidelines for about 3 years. So we've been doing a lot of work on that. But I'm going to start and talk about the book a little bit, and how we created it and what's in it and what we're looking forward to. And then Donna is going to take the lead and talk about the guidelines and what she's been doing, because she is the reporter, so she has had the bulk of the work on the guidelines and what's going on, and she's going to be writing them up, whatever we decide on. And as some of you may know, Donna is from New York, spent a lot of time there working, and still has an active practice. And I think that's one of the benefits that both of us see in our work in academia, is that we are not just talking about this stuff, we are both actively practicing mediation. And Donna's doing other work too that she may go into, but that's why it's really fun for us to be a part of this morning too, because we are both academics and practitioners. So I'm going to start sharing, but thank you all for being here. Okay. Sorry, jumping a little bit. My computer's been acting up this morning, of course, because that's how it goes, right? Okay. So hopefully everybody can see the screen where we're going to talk. That's a picture of Bowen in the background on a prettier day than today, but this is why we're here. So we will be talking about the book, which I have with me, which it's going to be the blue screen, but I'll pull it up later, and it is available from Oxford. And I do have a code that I can give people if they want to order it for a discount. I'll put that in the chat later on. But it is a book that has 29 chapters, 52 authors, and is really a work of just a lot of experts in the field. And I can say that not including myself or including myself. And we're just so proud of it. But one of the reasons that we're proud of it, and Peter Salem is the other author with me, who was the director, just stepped down this year, but was the director of AFCC for many years, and just knew everyone in the business, which was great. And we compiled this list of experts from many countries, mostly US, but Canadian, Australian. I think there's one from the UK, and put together this book because we didn't think there was one available that is this interdisciplinary look at where we've come from, where we are, and hopefully where we're going. And we really envision this book as something that's for a new practitioner, a grad student. I'm teaching it actually in an advanced family law family dispute resolution course this spring. It's being taught this fall in DC. So it's being used in schools, but we also think of it for any kind of practitioner, mediators, judges, caseworkers that are working on cases, psychologists, psychiatrists, lawyers who want to know a little bit more about what's going on in this area and get down to some specifics. So I'm gonna get pretty much in detail with what's going on with the book. But I thought this was so interesting because this is a quote that is not from our book. It's from a book that was published in 2004 that was written by Peter, but also by some other authors that talk about mediation. Now, we specifically moved to a family dispute resolution model to encompass more than just mediation because of the development of other practices. But it's interesting to me how 20 years after this definition, it is still very true that family mediation, and divorce processes is largely dependent upon who's doing it, where it's being offered, and what is being mediated. And we see in the family area a lot of differences. And if you're practicing in this area, I'm sure you have, between court-connected and court-mandated mediation and voluntary mediation. And whereas some attorneys, mediators, and others are focused on bringing their parties together, making a parenting plan, working toward the future, we also have a lot of people that are just focused on settlement and outcome and are driving it through caucus mediations and other things. So other people take a broader approach. We may see some collaborative law, some arbitration, some early neutral evaluation. Some places are doing financial early neutral evaluation. Some places are doing family or general or social early neutral evaluation. So it really does depend upon your jurisdiction, what the options are that are available. And so that's one of the things that we tried to get forward in the book, is that there are a wide range of options that you can engage in, but some of that is absolutely going to be dependent on what is available in your jurisdiction, how much money you have to do the process, and whether it's court ordered. Okay. So what we talk about in the book is this range of processes and this range of programs and this range of practice that goes on throughout family mediation and family dispute resolution. We also know that the courts have shifted in how they handle family cases, what they prioritized, and how everything comes together is dependent upon, again, your jurisdiction, but also what they've opened up to, what they provide, and what they mandate. So the first section of the book, after we have talked about, well, I should go back just for a second. So this is the first chapter of the book that Peter, I, and our wonderful graduate student worked on. And and that just talks about the history. Then we move into the first section, which is the background and some current practices, because we think it's important to recognize that depending upon your jurisdiction, up to 70% of these cases are there are self-represented clients involved. Either the clients are, either you have one side that is self-represented, which is people who practice these nows can be more difficult than anything, or you have both sides that are self-represented, which can get very difficult for court personnel and other people. So we talk about the background of family mediation, where it came from, where it's going, some objections to it that were early on, and some current objections to how it's being used in some jurisdictions. We also had the benefit of talking about child-inclusive mediation, and child-inclusive mediation is a model that's different than just having the child be a voice in the mediation. And Jennifer McIntosh, who is the brilliant author of this, is Australian and has created different programs based on how inclusive people want their children to be in the case. And that's important. The mediation model for self-represented parties comes out of the idea that in Wisconsin, people got together to work on a model that allows parties to go forward self-representing themselves, but with the assistance of attorneys without full representation. And it's a great program that they worked very hard in Milwaukee to get going. And it's a great model for courts that want attorneys to be involved, but aren't going to be able to do full representation. Second part is the second program or second section of the book is about various programs that are important in different parts of the country, how things are being done to help parents with this process, and what else is going on. So we start with a chapter on parenting coordination, and how that works and what it looks like and the importance of it. Then we have Colin Rule, who is the IT person. And actually, Peter and I, if you're interested in learning more about this, Peter and I were interviewed for a webinar, and that's posted to mediate.com about the book. And we're excited that different authors from the book, not everyone wants to do it, but some of the authors from the book are going to talk about their chapters in future webinars on mediate.com with Colin. But Colin does a great job of talking about how online dispute resolution is a newer space for family mediators and family mediation, and the pros and cons of doing it and how it evolved. And Colin is someone who I've had lots of talks about this because he, like I do, share some concerns about the online space, but recognize that it can be incredibly important for people in different parts of the country or different parts of the world, and provides opportunities for people to mediate when they couldn't before, but also that we need to put safeguards in place. And I'll talk more about that when I talk about IPD in just a minute. We talk about early neutral assessment. There's programs in courts that don't have any kind of traditional mediation that do some early neutral assessment that that also help low-income unmarried families to talk about family time and parenting time in a way that they previously couldn't. And they found that it promotes better communication between the families and relieves some tension in those families, which is great. Then we have one of our experts Barbara Atwood, talking about family arbitration and how it's being used and how widespread it's becoming and what the rules and ethical guidelines are if you're doing arbitration. And arbitration can be a great choice for families that want to resolve something, may want to do it more privately than they can do it through the courts, and obviously want it expedited. As always, arbitration can be a great resource if you need a particular expert in a particular area of family business or something else that can really help you to get to decisions quickly. And then we talk about the evidence that supports parenting education. We put under the umbrella of dispute resolution, parent education, and we think that's important because we think that when you include parent education, it helps them to learn how to resolve their disputes or how to handle the conflict that comes up between them, and is an important part of the next I was going to say next generation, too much. Of the next phase of their family experience. Okay. So critical challenges in family dispute resolution. First of all, I just have to comment on these co-hosts and their just speed with their sites and with their links. It is just awesome to work with them because they are just on it. So the next section that I think is really important, and not just because I wrote one of the chapters, is on critical challenges in family dispute resolution. And this is where we really have seen that there have been some changes in the conflict, some changes in how we define things, and important areas that mediators need to know more about and practitioners need to know more about. So this is just as much a section for family lawyers as it is for mediators and judges. The first part is managing intractable conflicts and shared parenting arrangement. What happens when there is that high conflict? Not every case is high conflict, but when there is, how does that get managed in the best interest of the children and to help these parents? If they're not co-parenting, right, they're parallel parenting. What does that look like? What does that mean? How does it work? How does it work for practitioners when there is high conflict in these families? The next chapter is mine, and this was even though I'm the author, it was a collaboration with several other people that really helped me to move this to get as much as I wanted to say within one chapter. And the big theme for my chapter on intimate partner violence is a little bit on the definitions, and we'll get to talk about that a little bit later with Donna with some of the issues that we had with the guidelines and talking about definitions of intimate partner violence and domestic abuse and intimate partner abuse and how that waves between jurisdictions. But the other part for intimate partner violence for me was sharing some not so great statistics about how many lawyers and how many mediators are screening and doing separate screening and doing, in both verbal screening and written screening, because screening is essential. We know, and I say we, anyone that's been involved and worked in advocacy for domestic violence survivors or others have worked in this area know that there is a lot, unfortunately, of domestic violence, especially at separation. Separation is the most dangerous time for survivors. And separation is when many of us are dealing with these people when they separate and when they divorce. But we also know that there's a real difference between domestic violence, the impact of domestic violence, the intent behind domestic violence, and what's going on in some cases. And it's important to differentiate and to look at what coercive control can mean in our processes, even if there's no ongoing violence, even if there hasn't been recent violence in a relationship. The fact that there have been coercive control in the past means a real impact on people being able to negotiate for themselves. And so it was important for me in this chapter to get across the idea that there are cases that should not be mediated. One of the things that I teach my students, in fact, I was just talking to them last week about this, is that everything is negotiable and not everything should be negotiated. And we really want to be careful in instances involving coercive control where there was a pattern where people are impacted either through trauma or PTSD from what's gone on in the past, that they are not able to effectively negotiate for each other. And so the main purpose of this chapter was to update people with the science of what we know and to give them a look at different screening tools. Now, New York has an amazing screening tool that I was not able to accomplish to fully put into the chapter because of the timing of it, but I would encourage everybody in New York to look at their tool. And Donna knows all about that from her work in New York, and we can talk about that later. But the idea was there's a great Canadian tool. There's a couple of great tools in the US. And going back to a previous topic of online, the people that put together one of the tools that we talk about have created an online version of that tool. And we can talk about that later, but I do want to get through the rest of the book. Bill Eddy talks about working with clients with high conflict personalities. And of course, that's a huge range, right? And that does not mean that those people should be singled out or there should be any negative emphasis on that, but gives tools for people to help both the facilitators and the participants to get to a resolution if that's the appropriate way to deal with people with high conflict personalities. Finally, in this section, the substance abuse disorders, talking to people about the impact of these disorders, what it means when someone is abusing a substance, whether that is alcohol or a legal drug or an illegal drug, and how that impacts both the process and the parties and what future agreements you want to create, I think is a really important piece. Unfortunately, in family mediation and other dispute resolution processes, we are seeing more and more people that are impacted by the use of different substances, whether they're legal or illegal, and how that might impact both your process and the agreements that you come up with. Okay, next section. So I'll get to we'll talk about the tools at the end when we have time. Thank you for the question. Okay, oops, jumping ahead. So the varieties of early negotiation processes is important to talk about, that E&E and the other processes that go on right when a case starts. That's by John Landy, one of the most prolific writers we have in the family dispute resolution piece. The next chapter was written, the evolving role of lawyers in family dispute resolution was written by a practitioner in Chicago, Beth McCormick, and by Carrie Cass, who is a professor up in Connecticut. And they talk a lot about collaborative law, but also how attorneys might show up in mediation and how they might not, and how they might have a full role in a case, or they might be hired and just work in the mediation or in court, and how important it is, if attorneys are on a case, that they show up at the mediation and at least do a good job of helping people to prepare for mediation. One of the startling things that I came across in doing research for a previous article that I wrote about working with self-represented parties was, I thought that there would be a big gap that mediators saw between the preparation for self-reported parties and self-represented parties and represented parties. And what I found, unfortunately, was that lawyers were not preparing their clients for mediation. They were expecting the mediators to screen the parties. They were expecting the mediators to tell everyone about the process. They weren't preparing them. And one of the pieces that this chapter focuses on is the need to prepare parties for the process, and for attorneys to be involved so their clients feel like they're being heard within the process. The child participation and child advocacy is written by some other professors who actually practice and represent children as ad litems in court and in mediation, and talk about how to get children's voices involved. And then we have Woody Mostyn, who is a favorite among all of us, who has written a ton about unbundling and limited scope, writing about limited scope legal services and how to work with parties who are using limited scope services. One of my favorite areas, and I'm going to have to jump ahead, is culture and diversity. And all of these, I think, are really important. Writing about culture and how culture impacts the people that are going through the process and the practitioner. Gitu did an amazing job of talking about the different ways that the intersectionality of race and culture and age and all of the things that impact how mediations work, and what facilitators should look for and what attorneys should be aware of with their clients. Then we have a great chapter by two of the best writers who write all the time about special needs children and working with them. And we know, unfortunately, that the statistics show that parents of children with special needs tend to divorce more often, and the complexities that are involved. If one parent thinks that a special needs child needs this kind of service and needs all of these interventions, and the other parent thinks that maybe they don't need those interventions, maybe it's close to home because the child has some of the same symptoms or diagnosis that they had, and they're very aware of this. So all of those different features, and it's an excellent article with definitive answers in some areas for how to deal with these families and how to help them. In other cases, a variety of options to help practitioners. Finally, Alan Barsky wrote an amazing chapter on gender and sexual orientation and how it's impacted by the law, and how to help individuals that are having difficulty depending upon their jurisdiction. Then we move into more court-based and problem-based and program-based knowledge, and just had a variety of people who are doing this every day, work on case management, work on community planning, how to integrate everything that a family is going through in courts into one court, and a review of a very recent study. We snuck this chapter in at the end about how ODR is actually being used in different courts around the country. And then up in the Northeast, a family resolution specialty court that has been doing this for a while out of Massachusetts. No, I'm sorry, New Hampshire. All right, I'm going to have to look that up. Sorry, again, 29 chapters. But they have the Family Resolution Specialty Court and have a great multidisciplinary problem-solving approach. I'm sure Nikki will tell me where it is in just a minute. Okay, so special issues in this program, in this version of the book, talk about the social science research. Marcia Pruitt is on 3 different chapters in this book, and she is one of the gurus in this area. And she talks a lot about the research and how it all works. Then Greg Firestone, who's out of Florida, talks about confidentiality and privilege and the overlaps, and sometimes how facilitators and programs mix the two up, and how we should make sure that the clients know what the difference is between confidentiality and privilege. And finally, our last chapter is Arnie Scheinwald, dealing with multiple codes of conduct, how to make ethical decisions, because we know, depending upon what hats you wear in general and what hat you're wearing in a particular situation, whether you're the mediator, the attorney, the ad litem, whether you're a caregiver or a care provider or a service provider, or you're a therapist or a social worker or a judge, you have different ethical rules, and sometimes those ethical rules conflict. And if they do, what do you do about that? And it depends a little bit on what hat you're wearing. It depends upon your jurisdiction. It depends upon your main area of focus. But all of those things are important. And Arnie did a great job of wrapping up the book and talking about that. So those are the chapters of the book. The issues we didn't cover that I wish we had room for, though we were already 100 pages over what we promised our publisher. And I think we started with 26 chapters and ended up with 29. We didn't get to cover money and property, which is a big part of a lot of divorces. We didn't talk about the use in many jurisdictions, and I was just talking about this with Donna, because it's not as prevalent where she is or with what she does as it is here, the caucus model, and how people are really, in many cases in family, being driven by their attorneys into the caucus model because they do not want to talk about emotions or anything but that settlement. And I had a speaker come to my class yesterday, and that's how he does family mediation, and he's very successful, and the lawyers want to go to him. And he leaves it up to therapists or other people to deal with ongoing issues, whereas I have a bit of a different model. But also, we didn't talk about the kind of birth to death issues that I think are important in family dispute resolution that Donna and I have both been involved in different ways, which is child welfare cases, adoption cases, and elder guardianship. So I'm curious from the audience and from everyone, what do you think is missing from the book, or what do you wish we had covered? What should we do in the second edition, which is not going to be for a few years because I'm just recovering from the 4 years that we worked on this. And again, thanks to Peter Salem for coming up with the idea. He did the book back in 2004 that I quoted from earlier and had wanted to revise for a long time. And I think it was a great time for an update for the book. But I would love to hear in the chat what you think we missed. And now we're going to turn to Donna, and she's going to talk about the guidelines.
Great. Thanks so much, Kelly. So when I was a student almost 20 years ago, I attended these ACR-GNY talks with Maria Volpe. So being here as a presenter really feels like I've come full circle. So thank you, Maria and Nikki, for having us, and the other hosts. As Kelly said, I just wanted to give a little bit of context as how I was trained, just to give you a sense of when I come to this reporter role. I'll talk a little bit about the history, just to give you context of where I come from. So I'm trained as both a lawyer and a social worker, and I've been engaged in family and dependency mediation since graduating law school almost 20 years ago. Currently, I'm on faculty at UF Law School, where I direct the mediation clinic, and I'm the associate director of the Institute for Dispute Resolution. I was a clinical professor at Cardozo Law School for many years, and my first job out of law school was both as a panel mediator for the New York City Family Court Custody and Visitation Mediation Program and as a full-time court staff for the New York City Child Protection Mediation Program. And for the last few years since moving to join the faculty at UF Law, I've continued my private practice as both a parenting coordinator, and I continue to mediate custody and visitation cases for New York City Family Court virtually from sunny Florida. The specific reason that Kelly thought I would be good for me to join her is that for the past 2, she says 3. I mean, it's been a very long time. I can't, we talk about it. It's been a long time. I've been the reporter for the update to the AFCC ABA Family Law Model Standards for Family and Divorce Mediators. The model standards for family and divorce mediators are the ethical Bible, I would say, for mediators in this area. It's a place where you can come as a resource to check with when you come up with ethical challenges. So for the second half of our talk today, we had 2 objectives. The first was that we wanted to share a bit about the work that we're doing on the task force, including some of our successes and challenges. And then our second objective, for hopefully the last 30 minutes or so, was that we wanted to hear from you about the updates that you think should be made to the model standards. Okay, so just a little bit of history of the model standards that I personally find interesting. I hope that you will as well. It gives some context as to how the work has been done. So these are the third model standards for family and divorce mediation that have been drafted. In 1984, there were actually two standards that were simultaneously drafted. One was drafted by by AFCC. It had its own standards, and the ABA Family Law section drafted its own standards in 1984. Kelly, can you move one more slide? The AFCC were seen as a resource document for state and national mediation organizations, non-lawyer family mediators, and court-based programs, while the ABA ones focused primarily on lawyer mediators for establishing ethical practices for them in the infancy of the field. Next slide. In 1996, the family law section of the ABA believed that family mediation had expanded dramatically since the 1984 document, and a fresh look at the effort was required, so they drafted an initial document. Again, this is the ABA only. This initial draft was seen as too narrow and wasn't indicative of the changes of the family mediation profession, included the inclusion of non-attorney mediators. So they drafted these initial standards of practice. In 1998, AFCC offered to reconvene the Model Standards Symposium using the draft standards of the ABA as a beginning point of discussion. So this was the first time where AFCC and ABA Family Law, among others, you'll see there's a huge list on this slide. They came together to create these interdisciplinary or multidisciplinary standards in 2000. So there were several symposiums that occurred between 1998 and 2000. A large group of stakeholders met several times over the course of 2 years, and in the end submitted the 2000 Model Standards of Conduct for Family and Divorce Mediators to the ABA House of Delegates, and it was ratified in 2001. For me, the important thing to note about the 2001 model standards is that it unified several stakeholders from multiple fields, including attorneys, social workers, court mediators, and others. So now to our current work. Our group was initiated in December of 2022 by the ABA Family Law Section and AFCC. There are also representatives from ABA-DR, APFM, and ACR who hosts us today. The group is comprised of 16 experienced family mediators, academics, ADR court program directors, and family law attorneys. Our group has representatives from various disciplines with a focus on both private practice mediations and court-connected mediation programs. And we have subject matter experts on technology. Susan Guthrie specifically is one that comes to mind. IPV and DV, we have Gabrielle Davis, we have Nancy Versteeg, and we have Kelly Browe Olson, and many other areas. Okay, so what have we focused on for the last 2 years? The list of topics are technology, the next slide, Kelly, technology, IPV, DV, domestic abuse, self-represented litigants, voice of the child, self-determination or party self-determination, and informed decision-making, but we could talk about that later, privacy and confidentiality, mediator training, and guiding principles. So that's kind of where what we did is we came up as a full group, decided what we thought were the kind of primary areas that needed to be updated from the 2001 draft. And we split into subcommittees over a year and a half, I would say. And those subcommittees came back with feedback for the larger group, and we reviewed it. And those have actually mostly been integrated so far into the draft that we've been working on. So Kelly now in the next slide is going to talk to you a little bit. She was part of 2 subcommittees, one that focused on intimate partner violence and the other on technology. So she's going to share a bit of her work on those subcommittees.
Thank you. And Donna, I'm sorry I was a little slow on the slide transitions. I was trying to answer questions in the chat at the same time. It turns out I'm not as technically savvy as one might think, or as I thought I was anyway. So Donna has just done a yeoman's job in this. It's been amazing, her work as the reporter and trying to consolidate, as you might imagine, all of the work of all of these different people. But we thought that we would highlight 2 of the things that I think are very relevant from the book and very relevant from this committee in the work of the subcommittees, and tell you and gives me the opportunity to talk a little bit about the structure of this task force, which I think was really well done by the representatives that came from AFCC and ABA, which are Stacey Hurd and Nancy Versteeg, and again Donna as the reporter. But So insights from these subcommittees, what the larger committee did and decided to do, or the chairs decided to do, was divide up the group into whatever area they wanted, but to focus on parts of guidelines and then the big picture issue. And the two areas that I got involved in, also the voice of the child, was another subcommittee, because we have been doing this for a long time. I guess it is only 2 years, Donna. It seems like a little bit more. Maybe Peter and I started talking about this 3 years ago. But so what I loved was that there was a really knowledgeable group that talked about what we should do and how we should do it. And it's hard when you have people that come from different jurisdictions, and some are court connected and some are from academia, and some have been practitioners for 5 years and some have been practitioners for 30 years, to talk about how much detail to use and how much emphasis to place on this various issue. One of the things that was recurring was that party self-determination was incredibly important. And we wanted to focus on that. We also want to talk about informed decision-making. And are the parties not just, do they have some self-determination about what happens, but do they know what that means, what these decisions mean? Do they know short-term and long-term, which is an area I always emphasize with my students. They may just be focused on the short-term and thinking about what they want now, and they want out, or they want this, or they want that, but have they thought about the long-term? And I think one of the things we were talking about in both of these subcommittees was, how much detail do we need to use? Do need to be here within the model standards, or at one point there were guidelines for a short amount of time, and we could talk about that. And how much do we think that they're going to learn from other sources, or that they know from elsewhere? And we talked about capacity and what that means, and if that's even a term that we should be using. And then, for instance, with IPV, we thought it was really important to have a definition, but where, and define things with some specificity, but they could have, and this is one of, I think Donna will agree, one of the struggles we had is that both these topics, tech and IPV, we needed to update every single guideline about how this impacted a particular guideline. Maybe not every guideline with IPV, but with tech, it matters, right? But we also wanted to have a section that was specific to tech, right? The people on that subcommittee felt it was really important to just talk about how technology impacts these. Then there's the overlap between tech and IPV and how that is used. So we wanted to talk about coercive control. We wanted to talk about capacity. We wanted to figure out how to do it. And yet, if we define it too much, people aren't going to recognize their jurisdiction or recognize what they know about the topic. So we wanted to be careful of that. Obviously, there was a lot of updates to do on tech, yet we knew as a group that, and as individuals, that everything that we put in about tech, about the use of AI, about how you use online pieces, could be out of date very quickly. The changes that have happened in the use of artificial intelligence, or AI, over the last year and a half have been enormous, right? How much it learns, how fast it learns, how much it can mimic a person's voice in terms of what they're writing, as opposed to sounding like it comes from a computer. We know that it has become, and some people are calling it the fourth participant in mediations. When they use it, people are using it as a great tool. It needs boundaries, just like children, just like all of us need boundaries, how you're using it, what you're using it for. But we wanted to put in some guardrails, if you will, for how it's being used in these processes, but also emphasize that it can be a great tool. So we know the different terminology matters depending upon what jurisdiction you are. And also that we ended up having, and Donna, you might want to go into this more, but we're still working on it. But we are putting some information within the various guidelines that we think need to have an issue. And then for tech specifically, for IPV, a lot of that went into the definitions. And for tech specifically, we're looking at how to have a guideline that incorporates a lot of the information around the tech. Is that right, Donna? Okay.
Yep, yeah. So technology has, I'll go over it in the next slide, but technology has its own standard. And then it is also sprinkled throughout, and same with IPV, DV, and domestic abuse. And yes, it's the definitions. We worked very hard on those definitions to expand them to include some information. And we're toying with the idea of commentary still. I think that's still kind of up for question if that's going to
Yeah.
stay.
And I think commentary opens the door, and then if it's not there, does that imply something if we don't have something in the commentary? But we also felt like there were some explanations needed that doesn't need to be in a model standard, and where should that be? And as you can tell, I'm a proponent of commentary. All right, moving back to Donna.
Okay, so the next slide, yeah. So the current we've made a lot of substantive changes to the model standard so far. So the current draft of the guidelines, like I said, includes a new technology standard. It also includes technology kind of sprinkled throughout. It includes instructions on how to deal with IPV based on the most cutting edge research. It provides comprehensive instructions on promoting the child's best interest and promoting child voice. And it instructs the mediator to terminate under a broader set of circumstances where the integrity of the process is threatened. Okay, next slide. So we've made some progress, lots of progress. Like I said, the standards now include adequate information about IPV, screening, child's voice, and child participation. We've modernized. The standards now include adequate information about virtual and technical aspects of mediation, and also issues of confidentiality and how those interplay with technology. We've expanded competence. So the standards now expand on mediator competence, training, and more. Next slide. So we have had some different, there's been a few challenges on the project within the task force. And that kind of goes back for me to what I was talking about with the history. You know, you have a lot of different individuals with different views, different, it's multi or interdisciplinary, so different kind of trainings, different viewpoints. We talked about private mediators. We talked about attorneys who represent clients in mediation. So it's a very interdisciplinary task force, and then I think it creates some challenges within the project. One of the challenges I think was also based on different conceptions of who the intended audience of the model standards were. So we all agreed unanimously and easily that the guidelines should be primarily for mediators. There were some questions: is it for mediators and the public or the parties? So that would be one kind of group, or is it for mediators and judges, court programs, and perhaps as sample draft legislation? And I think if you viewed them in that one of mediators and the public versus the judges, court programs, you see the document a little bit differently. And so that was one of the challenges that we've had. So, okay. Next one. So I think we have I would say that we have the current status right now is that we have a lot of content that's already been included in the draft. We're moving to the editing stage of the standards. I'll be editing it in the next month, actually, for the task force. And then we will do group edits where everyone will be sending their comments. And we're hoping really to shorten it, to be honest. Right now it's over-inclusive, and we're hoping to really streamline it. One of the benefits or the advantages of the first of the 2001 model standards was their how concise they were and how focused they were. That's one of the things that people commented was one of their, you know, the best attributes of it. So we're trying to go back to that, but knowing that we have to update and include a lot of new things. And so we're hoping to have a draft for public comment by this spring or summer. I will say, oh, good. Thank you, Nikki. So Nikki's put in the 2001 model guidelines. So if people want to kind of look at those quickly, you can kind of see what the standards are, what the numbered standards are. So just in conclusion, I've found that the experience of being the reporter has been one of the most rewarding and challenging experiences of my career. I've really found it really interesting, just working with this task force, thinking about the issues. Like we said, for Kelly and for both of us, we mediate these cases. I do a little parenting coordination. We do custody and visitation cases. I mediate with my students all different kinds of cases. And then to go back and teach about it and practice it and then think about it as the reporter. I also got to write a textbook with some colleagues last summer and write a teacher's manual for that. So it's been a really interesting experience, just constantly diving into these model standards while doing all that other work. And I've really appreciated it. It's been one of the, like I said, rewarding and challenging experiences. So we were hoping now to move to talk with all of you and hear from all of you about some of the questions that we've had. We've done this presentation at ABA-DR section and also at AFCC at both of their conferences, their annual conferences, and opened it to questions. So Kelly, what do you think is the best way to
This was going to put this up here and then stop sharing, which is we would love to have a further discussion about guiding principles, what you think should be in the guidelines, if you have comments or thoughts about the book, but also for the guidelines, one of the questions that Donna and I struggled with that I think is really important is who is the audience? Because we have some people in our group that really think we need to write something for the participants, and we agree, but I don't think we agree that they need to be in the model standards. So whether that's in commentary, whether that's another document, but we really want to hear, especially from such a diverse audience as this, about what you think should be in there and what maybe doesn't need to be in there. But I am going to take these questions down and I can put them in the chat so that we can look at everybody and we can talk about whatever you all want to talk about.
And I am opening your ability again to unmute yourself. And if you want to ask your question live, you can. I just wanted to make sure that everybody knows that AFCC stands for the Association of Family and Conciliation Courts. Is that right? Just so
Yes,
that
that is
correct.
everybody joins our
Thank you.
acronym world. And I'm popping a link in there, and that's where the model standards currently live. I posted a link to a PDF of the prior version, and it's feels like it's long overdue for an update. So this is great work that you're doing. And Kelly just posted some of the questions.
Yeah, we'd love to hear from all of them, from all of you about thoughts that you have on any of the questions. And also, I guess the ABA would be good. So the American Bar Association. What's interesting is that the co-chairs are the ABA Family Law section and AFCC. Those are the two co-chairs. Like I said, that's based on that history piece that I was describing. And then the ABA-DR section is a member, as is ACR. And so that's also interesting because ABA Family Law and the American Bar Association Family Law is an attorney kind of led section.
Yeah, and really litigation based, their
Right,
family law
litigation.
section.
Their
And because
family
the
laws, yeah. And then the ABA, well, you know more about this, but and the ABA-DR section, as many of us kind of participate in their events and their conferences, is more dispute resolution focused. So it's just an interesting interplay of all the different stakeholders.
Yeah. And we do have the chair of the
Yes.
DR of the dispute resolution section from the ABA in our group. But it is interesting because the family law section, even though there have been members that are mediators or believe in mediation or take their clients to mediation, it is more litigation based. And so they have not been as interested in what our standards are, except as it relates to the court part of mediation. But it is a great and diverse group, which helps to make the standards more interdisciplinary, but also creates for probably a longer process.
I feel the challenges when you just talk about the diversity of the members of the task force and the committee, Donna, in trying to boil everything down to some model standards. I think all of us that work in dispute resolution know that even the dispute resolvers can sometimes be the most contentious individuals in trying to reach a good solution. So there's some questions that have been popping in. One of the ones that that was a little bit up that we might not have addressed is the issue of latency and different kind of speeds of connection when dealing with the kind of online issues. So if you want to start with that, and then you can pop to the next ones.
Thank you, Tanya, for that question. I think it's really important to consider what is available to the participants, where they are, not just the latency and if they're able to connect and what kind of connection they are. But, for some people, you've had to teach them that if they're on their phone, they can scroll to the left and see everybody who's in the room. But also for me, one of the issues with people with IT is safety. You can't tell who's in the room or who might be manipulating someone or who might be paying attention to someone else. else. And even if people kind of have you swing the camera around the room to see who else is in the room, people can be using other kinds of devices to follow or to track what someone's saying, even if you think it's private and in caucus. So I think people's ability to connect and also the safety behind that can be really important when we talk about online IT pieces of it. And just as a connection to that, I think someone talked about the need to include animals in the book or in the next version of the book or maybe in the teacher's manual. I think animals in custody cases have become a huge part of what goes on in some mediations and how it works. Cindy asked about when the standards are going to come out. That is a great question, Cindy. And I think that Donna and I would like a crystal ball and to know, but we are very much hoping to get them out, to get them to what the next step will be. Donna, do you want to talk about the next steps for the guidelines?
Sure. And you should chime in too, because so the plan is for us to work as a group, as a task force, and come to a document that we all feel comfortable submitting for public comment. This listserv, so someone did ask, how can I get access to see the document to give comments? And of course, we will be sending out to the listservs, to the New York City, DR listserv, to Maria's listserv for public comment. And then I actually don't, I'm assuming then we take in the public comment and we see about that. And then at some point, it's going to have to be voted on by AFCC's board and also by the ABA House of Delegates, which we hear is a very long and arduous process.
It is, having gotten guidelines through them before for child protection mediation, it is an arduous process, but they'll be available and kind of out in the public for both the comment period before we finalize them. And then once we finalize them, there are guidelines, or in this case, model standards. There'll be the model standards to have them be AFCC approved or ABA approved, AFCC sponsored. That's the process that has to go through their boards. So that takes, just meetings of everybody and getting it through, and we have to find sponsors at the ABA. Fortunately, the AFCC executive director, Brian, what did I just say?
Altman.
Thank you.
Altman.
Brian Altman, Peter Salem retired and Brian Altman took his place, and Brian's been a great steward for this piece, but he'll help get us through the board of directors at AFCC and just walk it through there. And we do have both ABA family law and ABA dispute resolution people to help us with the ABA board of delegates. But then it will become the public document and people can love it or hate it or do whatever they want with it. But we're hoping that it has the same uses as the old one, with updates in terms of the tech, IPV, role of the child, role of self-represented litigants, because we know that's become so important. So those updates we think will be important. Tracy asked about plain language, and I think that that's important. We are doing that to an extent, but I will tell you, as someone who's written manuals and brochures, mediation is an 8th grade word. So if you try to write something at a 5th grade level and use plain language, you can't use terms like mediation. So at some level, it will be plain language, but obviously it cannot be maybe as simple as we would like it to be.
We have, the conversations about having a separate document that would be for the public and a document that would be mainly focused on mediation practitioners has come up. And we're kind of navigating that if that's the solution. But and that, to be frank, has been a bit of a struggle with kind of figuring out what the document, what the intended audience is. Yeah. And making sure that it can get through the, House of Delegates and the AFCC board is part of it as well, like kind of figuring out what's going to really be helpful to practitioners and also what's going to make its way through the pathways it needs to go. Yeah.
There's a comment that participants should not be the primary audience, since the document is a standard for practitioners. And Harry, you are preaching to the choir, because both Donna and I think that it should be written for the practitioners. And we think another document that talks about self-determination and people's rights is absolutely appropriate and should be used with the standards, model standards. Donna and I are thinking that it should be written for the practitioners and for other people. And it is, we use it in our training. We use it to train and create when we're creating new mediators. Another great question, and Donna, I don't know if you want to start with this one, but are there cultural barriers faced by mediators when mediating these disputes?
You take that one. I'm going to read
Okay.
it. I have a good question
Okay.
here I think I want to address next.
Okay, so yes, I would say there are a variety of cultural barriers that are faced by some mediators. Mediators that are working outside of their own culture might not understand the patriarchy or matriarchy that goes on in a particular family. I've had that anecdotally, but also we know that people are more comfortable with mediators from their own culture. And you also might not understand the family dynamics that are going on that no one is talking about because it is so obvious to all of them, but not to you. Other culture issues that are covered in the chapter in the book that Gitu did such a good job on talk about how there with immigration, which is, I know, a very hot topic lately, but depending upon where a family is in their immigration cycle, if they're in the first generation of immigration or the second generation that have immigrated to this country, it can really impact how they talk to each other, how they treat each other, what their expectations are for each other and for outsiders. And so I think knowing some of these, knowing how this may be impacting a family and also not stereotyping, because just because someone is from a different culture doesn't mean that they are any different than they approach a problem any differently than you do. And so I think one of the issues with culture is talking to parties as individuals, as this particular, what is impacting this particular family is key. Because it's not to say that someone, because they are from this culture, will act this way. I think that's important not to do, but it is important to learn how outside forces and internal forces are impacting how a family interacts with each other. And that's why I think there can be cultural barriers that can be overcome, but sometimes, it isn't worth it if you don't take the time to understand what's going on with a particular culture and how it's impacting a family.
Okay, awesome. I wanted to address one of the comments, which has been a little bit of something I've thought a lot about with these guidelines is Corinne had said what informed consent really means. Some feel if a party has an attorney, that's informed consent. Some feel if you explain the mediation process to an unrepresented party, that's informed consent. This really needs to be defined for our unrepresented parties so mediators clearly know their role in this. So this is like a hill that I'm ready to die on, as we say. Like this is like, for me, one of the most important parts. Kelly and I have spent a lot of time speaking about this. For me, it's informed decision-making. I know the informed consent is, I know there's different academics have kind of outlined, Jackie Nolan Haley has spoken about this. Nancy Welsh. So for me, it's actually informed decision-making, and it's really knowing what the alternatives to not reaching a settlement are, knowing, especially in a court case, what exactly are the options that stand in front of someone. It's much deeper than, like, as you said, some feel if you explain the mediation process to an unrepresented party, that's informed consent. So for me, a lot of the work has been trying to highlight that piece. And so we'll see if I did a little bit of working, or we talked a lot about reorganizing the 2001, the structure of it in the sense of like moving the numbers around and the different standards around. And so I've moved right now informed decision-making to number 2. So it's right behind self-determination. We'll see if that, if the task force agrees with that. And so we're working with that piece. So Corinne, thank you so much. For me, that's something that
It's Cookie. I think it's Cookie Levitt.
Oh, really?
Yes.
Unless there's
Okay.
another Corinne Levitt. Cookie, is that you?
Yes.
Hi, Cookie. Yeah, I totally agree with Donna. Thanks for joining us, Cookie.
Thanks so
Cookie and I
much.
have presented before on IPV at AFCC and other places, and Cookie's a long-standing divorce, excellent mediator and trainer in Chicago. And I think what she's saying is really important, and I'll just, because we want to talk about other things too, but the difference between consent and decision making. And I think that goes to the short-term and long-term aspects of a decision and what people are basing it on. And Nancy Versteig has written about this too, in terms of, do people really understand the implications of having to negotiate with each other and the long-term consequences of that, and making a plan that's in the best interest of your kids or yourself or both? And are there differences there, and what that means? And are we ready to mediate now? Or do we need a delay? Do we need an advocate in the room? And so I think Donna's making it more of an umbrella, an idea of informed decision-making is crucial. And this is where we got into some discussions on the task force about how much are we prioritizing self-determination, which we both think is key, but it also needs to be informed decision-making, because giving somebody self-determination without really talking to them about the implications of what they're doing and how they're involved doesn't really help, right? And so are we sure that they understand both, that they get to make the decisions, but what the decisions implications will be are key?
I just wanted to also read out, we've, like I said, this has been an area that we've really thought about, Kelly and I and many on the task force. So I just wanted to share something that Nancy Welsh has recently sent to me. It's a deconstructive concept by Omar Shapira about party self-determination. So I thought this was really interesting, and maybe I could cut and paste it from my document. But so Professor Omar Shapiro has deconstructed the concept of party self-determination and urged that at a minimum, a sufficiently robust version requires 1, party competency, so a basic capacity to make decisions. We've talked a lot about capacity recently. B, voluntariness, so the ability to exercise free will. And C, information, making decisions which are based on relevant information. And he has urged that if any of these elements are any of low quality, the party's decision-making should be viewed as merely the exercise of formal self-determination, which should be treated as unfair or unjust. So I thought that was a really interesting conception of self-determination, and it addresses, I guess, what Cookie had shared with us and things that we're thinking about. I just wanted to address, Justina had said, any thoughts on how to get more mental health practitioners involved in family law decisions models? Sorry, on standards. As a long-term clinician, I am consistently shocked that family law decisions about children, not about the money, are made with little or no input from mental health practitioners. So in the current draft, like I said, it's really still in draft form. We talk a lot about having opportunities for parties to to get consults with different individuals, including mental health practitioners, religious advisors, attorneys. So we talk a lot about that informed decision-making piece, and including practitioners of all different areas to help with making good decisions. So that piece is currently in there. I hope it stays. It's one that I really like. And there's also the idea of termination. Both if the parties don't feel like they're comfortable with the outcome, they have the right to terminate at any point, and that's outlined, as does the mediator. So hopefully that. Let's see, what other questions? Will there be any consideration of AI? Could really use some guidance on that. So that's one of the big areas. Like I said, we had a technology subcommittee. Kelly was on that. Oh, sorry. It's hard to do the chat and speak at the same time. Sorry. So because it's so good, the chat, especially this one. So yeah, we're really focusing on that. Like I said, we have Susan Guthrie, who's an expert in technology. She's the current chair of the association, the American Bar Association Dispute Resolution Section, and she had a subcommittee. So there will be considerations of AI, technology, and also online case management. They're really kind of trying to be as inclusive as it can without feeling stale. So Susan talked a lot about, and Kelly, you addressed this before, that she wanted to make sure that our technology pieces were still current because things change so rapidly. So I think there's going to be some stuff on the pieces of AI, but it was also trying to be comments that would be helpful, that would be long lasting about technology and about AI and other things.
So I think that that some of this talk in the chat is about community mediators, and I think that we do address. I mean, I know Nebraska is amazing with community mediators and how they do things, and obviously there's no difference in how we treat them or how they should look at the standards, but that it's really important to think about what they're doing and how they're working within this field. And so we do talk about that. We do have other pieces of this, other pieces that we think might be in the commentary that are not necessarily a standard, but are related to how that standard would be applied. And as Donna said, that's one of the things that we're still working on.
I just want, there's a little bit of a conversation going on about community mediators, and whether or not they're a separate kind of, it seems like maybe someone's thinking that they're a different section of mediators, court-connected mediators and private mediators, and then community. From my work, at least in New York and New York City, community mediation mediators seems to be is definitely included in that version of it. I think, as someone said, that they, they're under the ethical guidelines if they're mediating custody visitation or divorce cases in the jurisdiction. So we're definitely thinking about those. And there was also a question about rural mediation and dealing with rural parts of the state. And I think, with the online portions of mediation, we tried to address that as well.
I think that just some really interesting things in the chat. So I hope you get to view it. But I do think one of the things that we have thought about and talked about and are trying to figure out how to incorporate is the difference between court mandated mediation that happens and there's not a lot of time and you have to do it immediately, and then private mediation, which can be in the rural area, can be in the community area. And I know that there is some overlap in some jurisdictions where community mediators are doing it all. Right, they're doing the court-connected mediation too. So these different models are addressed in the book, in the guidelines, not as in the, and I'm going to keep calling them guidelines because we've been back and forth. The model standards, not so much. And that's why I'm saying I think there's room for some commentary maybe, and talking about how this impacts different people. I know that some people don't have the resources to do a 3-hour mediation or to do, a multi-session mediation, which in my mind is the gold standard, because people are not always in the same place in one day, right? But we know that people do it differently and do it well. And it's not a monolith, that there is a continuum of processes that work. And one of the things I think that we are trying to emphasize in both the book and the standards is that what we should be doing is meeting the parties' expectations. One, meeting the parties where they are and not expecting more of them than they can provide, and helping them with their to figure out that they should have self-determination and what that means to them. But I think that also goes to Cookie and Donna's earlier point about informed decision-making for the now and later. And I think that's an emphasis we need to keep involved. Barbara talked about collaborative mediation, and I think that's a newer tool that people are using. I think it's really important. I know Donna addressed a little bit of this in talking about the interdisciplinary experts. But as we're seeing more pro se parties, I think the mediators are going to need more tools in their arsenal, like collaborative mediation, depending upon, are these parties that for capacity reasons or for other reasons really need to have some kind of advocate in the room? What are the mental health considerations? We've known for a long time that family law is not just law, right? It involves so much mental health, so much psychology, all of the other interdisciplinary factors that need to be considered when people are going through these processes.
Tanya just said the capacity of the parties is definitely a great impact on the outcome. So we have a whole capacity standard. It's one that we're working through very closely. There's been a lot on mental health and capacity. There's a lot that can be written about that. So we definitely think it's one of the, focus areas. So we really think it's an important area, and we're going to focus on that with, like I said, with one of the standards. Yeah.
What other questions do y'all have?
I think some people want your code, perhaps.
Yeah, I'm pulling that up right now. It's
So
it's a PNG. It won't let me. The format won't let me put the flyer into the chat. So I'm just going to put the code in. But the code only works through Oxford. And so you're going to put in, I'm going to put just the code in, but because I can't do the whole flyer, but this is the code to get 30% off the book. And if I can find a way, I've been trying to get the whole flyer in there. Maybe I can send that, and they can post the flyer with the with the piece, because it's not letting me, for some reason,
Oh.
paste it in there.
Kelly, one of the ways in which we've been doing this, since we don't allow attachments even on the listserv, is having people save their documents in a Google Doc and then just sending the link
Okay.
so that they can click
Here,
on the link.
I'm
I
going
know
to
that-
post it real quick. How about
Okay.
that? And then I will do that. So this is the flyer. And I'll see if I can do what you were just suggesting as a Google Doc. Let's see. Oh, probably not while I'm sharing it. Okay, well, this is the flyer. I put the code in the link, and let me I'll stop sharing it and make it a Google Doc.
The code hasn't popped up yet.
Okay, it's ASPROMPS 8. I think it went at just a minute ago.
It's in the chat.
Let's. Yeah, it just popped
Yep.
up.
I think we've addressed most of the questions that were in the chat. Does anyone else have any thoughts or questions?
I think there was I don't know if you addressed this fully enough or whether it kind of exceeds the scope, but there was a question about co-mediation and the use of
Oh, right, yeah.
that.
You noticed I didn't so I didn't address it. I actually don't know if that's addressed in I feel like there might be one, like, they're numbered points. So there might be one numbered point about co-mediation. Kelly, do you remember? It wasn't something that was a focus point, I will say. I believe there might be one subsection that addresses it.
Yeah.
Is
Yeah,
that
we do not spend a lot of time on it. I think that it is important, and it's something that I definitely teach when I train. So that's a link that should get people to the flyer. Hopefully that will work. But I do think that it is an important aspect of it. And I always say you have to model good conflict resolution, and you have to know what you're doing as a co-mediator. I'd be interested in hearing what you all think we should be including about co-mediation, or when there's a co-mediation model. I know one of the things that we talk about at the community level is that it's hard to have the resources to provide co-mediation, and co-mediation can be a resource, and an important resource. The best team I ever saw do family mediation was a gentleman who was a psychologist and the wife who was a divorce attorney, and they did amazing work together because they covered all aspects of this. And I think it's a great model. And some of the mediations that I do my program here does special education mediations throughout the state of Arkansas, and we can have up to, 16, 17 people in a room, and co-mediation, or at least having a scribe or somebody else in the room, is essential in those cases, because you just can't handle it all as one person. So I think that co-mediation, especially if you're divorcing with opposite sex couples, having a man in a room as co-mediator, a man and a woman as co-mediators, can be incredibly helpful. And
so, Kelly,
Mhm.
sorry to interrupt, but one of the questions that we've had when we've done this is we don't want it to be the how-to. So it's not supposed to be a how-to on how to mediate or what's best to mediate. If you look at the 2001 standards, you'll see that it's really thinking about the ethical principles. So I guess if you could think of, I see that a lot of you say that they practice 100% co-mediation and family mediations for CDRCs in New York State. That wasn't the case in New York City, or still isn't the case in the New York City custody and visitation cases, but perhaps in the divorce it is. But I guess could you share with us what you think might be ethical issues that arise, or what needs to be put in an ethical code regarding co-mediation? If that distinction makes sense to all of you.
And while people are doing that, I'm just going to someone asked about the highlights or the differences in the new standards. Obviously, we are still putting them together, so they haven't been finalized. But I do think that there's a reorganization because the organization, as Donna emphasized, didn't really make sense. And we are putting a new emphasis on informed decision making. We are making it clear that not just the mediator can stop the process, but the parties should be able to stop the process if they want to. There's a lot more language on IPV. There's a lot more language on tech. And talking about sort of the definitions and when people, how to empower the parties to be making choices about their mediation. We talk about the voice of the child and how they should be included, but how they shouldn't, be forced to make any decisions, obviously. Donna, what else would you say are the newer pieces or highlights? Or
You said technology, right?
yeah, you can go into a little more detail if you want about it.
And the capacity issues. So thinking about how to we talk a lot about a piece, and I don't know if this is going to survive. Some of this is the things that are really that I've seen from the years of practice, but the initial screening and assessment has a much bigger piece. What was striking to me, as Kelly knows, is we sat at the ABA-DR conference and presented on this, and one of the mediators raised their hand and they said, what, you need to screen in family mediations? And so that really got me concerned that we needed to highlight it. So there's at the beginning of the standards right now, there's an expanded kind of initial assessment capacity, thought and screening area. So to really address some of the the areas of that initial phase of mediation and how important that is. So technology, child's voice, a little bit of a more thoughtful assessment of capacity, and how to address capacity. Technology, of course, an expanded IPV standard. The standard on IPV is quite expanded. Interestingly enough, neutrality and impartiality isn't actually very much expanded. We just heard a lecture on that at a conference, but that hasn't been expanded. Oh, and issues of training for mediators and what you need in order to be a good mediator, which of course focuses a lot of technology these days, being up to speed on the technology resources that you're going to be using. I did want to send a shout out. Yeah, Professor Love, they're having a celebration of her career this evening in New York City, which I am sadly not able to attend. It's hard for me to leave my 4 children with my husband for periods of time. So I wasn't able to join, but was my initial professor and my mentor. So a big shout out to that celebration and to be able to celebrate her career, which influenced many of us.
She's great. And I have friends from around the country that are going to be a part of it. And I wish that, yeah, we could all be in New York to celebrate all the wonderful things she's done for this field.
Yeah.
For those of you who are going to be in New York tomorrow, there is an all-day conference at Cardozo as well.
Great.
I will try to remember where I put the link and put that in the chat as well.
Yep. And they're actually having a student competition on Sunday. They've really stacked up the events. So some of my students from UF Law School will be competing on Sunday in a negotiation competition called Cinema. They've been running a really nice tech and arts and media negotiation competition. So that's on Sunday. So it's a very busy weekend there in Cardozo. Yeah. Any other questions or thoughts? It seems like people are maybe putting in some ideas on future events. Maria did talk about how, which I'm great, I'm excited to come to it, that Baruch Bush will be talking about self-determination on January 9th in one of these ACR-GNY events. So I'll definitely tune into that, Maria. Thank you for doing that. Yeah, thank you also to you, Maria, for all your hard work.
Yes,
cultivating
thank you,
the-
everybody.
Yeah.
Thank you, our hosts, and Maria for inviting us to come, and for everybody for participating. And our last slide, one of the things we had was was our names, but they'll be sending all of that out. I guess we can put them in the chat for our email addresses, Donna, so that people can connect with us personally if you have more questions about the book or the guidelines or just anything, because we're professors, so we're used to being resources. And I'm happy to chat about everything, but it's been such a pleasure, and I appreciate y'all as an audience and for being here early for some of you, early for us Midwesterners and West Coasters.
Yeah.
Early for some, late for some. And also I wanted to remind everybody that the public chat will also be another resource that's uploaded. So all of the great links and questions and responses, thank you to our speakers for being engaged as responders to the chat, will also be posted online on the ACRGNY website and also on the John J. CUNY dispute resolution website. There'll be a link to it there. So they've just posted email lists. I know that a lot of the excitement and energy around the chat was about how people can engage and be involved as these new standards, model practices, whatever they're going to be called, come to fruition. And so we'll be sure to keep everybody posted on the listserv about how to stay engaged with that. And now that all of the attendees have your contact information, they know where to hunt you down. I also posted your academic homepages a little bit earlier in the chat.
Thank you.
You are now officially inaugurated into known resources in the Roundtable Breakfast, cohort and collection. So welcome and thank you, and please everybody be energized and
engaged when
and
when they
engaged,
come
yeah.
out for public comment, feel free
Yes,
to
please.
submit.
We
Please,
would love
we
feedback.
would love feedback on we'd love feedback now if people have, don't feel for the co-mediation needs to be addressed, and there should be some ethical not, I wouldn't say a standalone standard, but how we can integrate it and what's interesting, what's important to you. We'd be happy to hear it, as well as future public comment. And Maria will make sure to send it through the listserv, so it will come to you, since that's such a good resource to get so many people involved.
And
So thank you all.
I think you'll discover experts like Deborah Hamilton is a specialty in mediating pet disputes. And so maybe that's a pocket part or an additional chapter in a forthcoming book, if not an addendum to the current model. I know that was just kind of top for some reason in France. That was just on the headline news that pets are still treated as chattel in divorce law here, and people were quite upset about it, which they don't often realize in many U.S. states as well. So be careful who pays the adoption from the SPCA. It could matter.
Yeah, there was just a big case about that, and a woman spent thousands of dollars, and the court decided it was his property,
Yeah.
and the pet, and it was devastating.
Yeah.
And so people do need to pay attention, especially the more we treat our pets as family. So
Exactly.
As we're
But
talking about new topics, I was just wondering if you've given any thought to any special consideration of Gen Z. I mean, will they be different for this process? Perhaps content-wise, a whole generation being raised on technology. What kinds of issues does that bring to the table for resolving future family situations?
I think it definitely impacts both how they form and what they consider to be a family, but also how we address it through tech and other ways. We think about, how crazy is it to just do an online divorce, but young adults and Gen Z who've been living their life online, they don't see any difference about it. They sign forms. I don't know if you saw this, and not to bring up politics again, because it's been a really rough week, but I know that there were a bunch of students who were rejected trying to vote because their signatures didn't match. And why didn't their signatures match? Because the first time they did a signature was online, and they just did what we all do, which is like a couple of lines. And then they showed up with their driver's license and to sign it in real person, and it looked nothing like it. Well, we need to fix that, because that's how everybody is signing things online right now. And so I think that, that's obviously an anecdote and not, but it matters, right? How people are doing things. And if they're living their lives online, how do we adapt our processes to meet them where they are?
Excellent.
absolutely.
Well, we have just about reached 10 a.m. and it's at this point that we thank our speakers profusely for such a wonderful presentation. I think you've been seeing all the messages of gratitude in the chat from all of us. Thank you, thank you, thank you so much. And we will officially turn off the recording and look forward to seeing you next month when Peter Adler, who some of you may know from his work in public policy work, who has a new book coming out, will be talking to us about the book called Calming the Storm, A Leader's Handbook for Managing Unproductive Conflicts. Peter is in Hawaii, so it will be very early in the morning for him. Look forward to seeing everyone on December 5th. Thank you so much for being with us and see you next month. Thank you
Maria,
so
one
much.
thing, Maria, one thing that I did not mention that I should have, because we're talking about it, is AFCC is having their conference in Columbus, Ohio. It's unfortunately the same time as the ACR conference. But if anybody's interested in learning more about family issues, there's an AFCC conference, and you can find out more about it at afccnet.org next week. And we are talking about the standards again, and I'm also doing a plenary on the voice of children in family mediation. Sorry, I should have mentioned it earlier.
As a footnote, you can also send a message out to the listserv,
Okay.
and it will get to, as many of you know now, over 4,000 subscribers in over 25 countries. So spread the word. I mean, we need to be able to get these messages out to everyone.
Wonderful.
Okay.
Excellent.
Thank
Thank
you
you so
everyone for
much.
coming and see you next month.
Thank you, everyone.
Thank you, Maria.
My pleasure.